Hello, champions. I hope you are doing well and I hope you are nice and ready to handle the examination today. Now, see, just listen to me for 1 minute and then we will enter into the main part of the video. I prepared a similar video before the May 25 exam as well. I prepared a similar video before the September 25 exam as well, and this is the third time when I'm preparing this video. For every examination, it's a new video which I prepare. Top 50 reminders, the last minute 50 reminders just before you enter into the examination hall. I want you to listen to these 50 reminders. These are not random 50 reminders, no guys. These are those 50 concepts which according to me are highly probable in your examination. They are those 50 concepts where silly mistakes are possible from your end in the examination. They are those concepts which you just cannot afford to miss before you enter into the examination hall. So it will be like the perfect last minute touch to your preparation. So ensure you watch as much as possible of this video, okay? Trust me when I say this, in the May 25 examination as well, in the September 25 examination as well, this video had made a huge impact on the performance of the students. Of course, I'm not saying that your entire question paper will come from this video. Impossible, guys. It's only a 1.5 hours video. But however, I can assure you that a minimum of 10 to 15 marks you can expect from somewhere or the other from the concepts covered in this video. Okay, so therefore, watch it with confidence, knowing that this video is going to help you ace the examination. Alright, so that's it guys. With this, the main part of the video starts. I'll be quickly taking 50 reminders. I've arranged the 50 reminders chapter wise. So one by one each chapter I will be revising. I'll be giving you a reminder of certain crucial provisions. Ensure you listen with an open mind, and by chance you realize you've forgotten something, don't panic, it is okay. You will tell yourself, give me as much learning as possible before I can walk into the examination hall. Okay guys, with that mindset, go ahead and watch this and finish this till the very end properly. Starting off with the kinds of companies, I have two reminders for you over here. The first one is relating to one-person company and the second one is relating to subsidiary companies and holding companies. Now when it comes to one-person company, every one-person company is by nature a private company. So every one-person company's name should have the words private limited in the name guys. And also every one-person company's name should have the words one-person company or OPC at the end of the name, so that everybody who's entering into a contract with the company knows that okay, this is a one-person company. So conclusion, every one-person company's name should have the words private limited and at the end in brackets one-person company or OPC as the case may be. Then comes the second point. We know very well in one-person company there's only one member. This one member will appoint a nominee. In case a member dies or in case a member becomes incapable, then that nominee will become the member. Now that nominee has to give a prior written consent saying that the nominee is willing to be appointed as a nominee of the one-person company. But later if the nominee wants, the nominee can also withdraw his consent. So if the nominee withdraws his consent, now the one-person company is not having a nominee. So now in such cases, within the next 15 days itself, the member of the OPC has to appoint a new nominee. Whenever there's a change in the nominee, we have to inform the ROC about the change within 30 days. Okay, so this was your first reminder with respect to one-person company. Two reminders. Reminder number one, every one-person company will have the words private limited and one-person company in its name itself. Point number two, every one-person company has only one member. That one member will appoint a nominee. In case a member dies or in case a member becomes incapable, the nominee will become the member of the OPC. Now, the nominee has to give a prior written consent saying that he is willing to be the nominee of the OPC. But if he wants later, he can withdraw his consent. If he withdraws the consent, now in the OPC there is no nominee. So within 15 days itself, the member has to appoint a new nominee. And from this new nominee also, we have to get written consent and all that. Now whenever there's a change in nominee like this, we have to inform ROC within 30 days. Okay, first reminder. Can I say you've understood this? Now come to the second reminder. The second reminder is about subsidiary companies and holding companies, section 19. Okay, see, no doubt, generally, my general rule is that a subsidiary company cannot hold shares in the holding company. It is prohibited, it is void. In case the holding company allots any shares to the subsidiary company, or in case any holding company's shares are transferred to the subsidiary company, it will become void. Two things I spoke about: allotment will also be void, and transfer of holding company's shares to holding company, even this will be void. But however, there are three exceptional cases. In these three exceptional cases, the subsidiary company can hold shares in the holding company. Exception number one, when subsidiary company holds shares as legal representative of a deceased member. Number two, when the subsidiary company holds shares as trustees. And number three, Even before the holding subsidiary relationship was formed, even before that, the subsidiary company had owned some shares of holding company. Those shares the subsidiary company can continue to keep. Alright, so the shares which subsidiary company had held even before it became a subsidiary. So in these three exceptional cases alone, the subsidiary company can hold shares of the holding company. Number 1, as a legal representative. Number 2, as a trustee. And number 3, the pre-existing shares. Now in such cases, in these three cases, we are letting the subsidiary company hold shares in the holding company. Now for those shares, the subsidiary company will also get voting rights. So in the first two exceptions, the subsidiary company will also get voting rights. But however, for the pre-existing shares, the shares which subsidiary company was holding in the holding company, even before the holding subsidiary relationship was formed, for those shares, voting right will not be available for the subsidiary company. Understanding, whatever shares subsidiary company is holding in the holding company as legal representative or as trustee, for these shares subsidiary company can enjoy voting rights. But however, whatever are the pre-existing shares, with respect to those shares, yes, subsidiary company can continue to own the shares, but however, no voting right. Okay, 2 reminders done. Now comes my third reminder. This is a very important one, something which many of you might find it a new point, but don't get disappointed. It's okay, right? Exam is tomorrow, so even if I have a new learning today, it is fine. So listen to me. See, we're talking about section 6. Section 6 says that the act, your Companies Act, overrides MOA, it overrides AOA, it overrides agreements, and it overrides general meeting resolutions and board meeting resolution. Which means if the MOA, AOA, agreements or resolutions, if they are against the Companies Act, the Companies Act will prevail over all of these. Okay, so like for example, if in the MOA there's a clause which is opposing the Companies Act, if there's a clause in the AOA which is contradicting with the Companies Act, so if there's a conflict, which of the two will you give priority? You will give Companies Act the topmost priority. Okay, so that is what I have mentioned in this chart as well over here. Any provision contained in these documents, if it is inconsistent to the provisions of the Act, then that provision will become void. Understanding? So in simple words, Companies Act is superior. Anything written in any of these, if it is against the Companies Act, then these documents will become void. But however, the best part, the most important part here is that section 6 starts with a savings clause. That is, it starts with the words save as otherwise expressly provided in the Act. This means that generally Companies Act is superior. Everything else comes below Companies Act. But however, in the Companies Act itself, in any section, if it is mentioned that these documents are superior, then these documents are superior. Like for example, if you see section 50, which talks about calls in advance, okay, section 50 says yes, company can accept calls in advance, but however, only if authorized by AOA. So don't you think now section 50 is giving more power to the AOA? So now it all depends upon the AOA. If AOA says company can accept calls in advance, then the company can accept calls in advance. If AOA says company cannot accept calls in advance, then gone, company you can't accept calls in advance. So even though Companies Act is saying yes, company can accept calls in advance, but the Companies Act is also giving more power to the AOA. Only if it is authorized by AOA, only then the company can accept calls in advance. So because of this savings clause which is mentioned in section 6, whether Companies Act is superior or whether these documents are superior, it will depend on each section. Like for the purpose of section 50, if you see, AOA is more superior. Understanding, guys? Yes. So this was your third reminder from MOA and AOA. Now one more reminder relating to your MOA AOA chapter, section 20. It's been a long time since you've tested this. We're going to be really careful about this. See, if any person wants to send any document to the company or to any director of the company, they will send it to which address? To the registered office address. By what mode? 5 options we have: registered post, speed post, courier, email, or by simply leaving it at the registered office personally. Okay. Similarly, if the company wants to send any notice to the ROC or to the member, then they will send by the same 5 modes plus one more mode, which is ordinary post. Alright guys, simple. So if I want to send a notice to the company, or if I want to send a notice to the director of the company, I will send it to the RO address, okay, registered office address of the company, and I will send it by which mode? 5 options I have: registered post, speed post, courier, email, or personally I will go and leave it at the RO address. Similarly, if the company wants to send any letter to a member of the company or to the ROC, the company will send it by the same 5 modes, but one more mode is possible, which is simple ordinary post. Okay, now listen, I have the last 2 points over here, listen carefully. See, if the member of the company is the recipient of the post, then in that case, the member can request the company that send the letter to me by one particular mode only. Like for example, member can tell the company send the letter to me by speed post only. So in that case, the member will have to give a certain amount, a certain fee to the company. How much fee will be determined in the AGM. Okay, but tell me, if the company is a recipient, like for example, if the company has to receive something from the member, can the company also tell the member that send me by speed post only? No. Who can request? Only the member can request. If member is a recipient of the letter, the member can tell the company that send the letter to me by this send the letter to me by this particular mode only. Okay, so member can request, company cannot request. All right. And one last point, whenever the member wants to send any letter to the company, the member will send it to which address? To the RO address, to the registered office address, guys. Similarly, when the company is sending notices to the member, the company will send it to the registered address of the member only. Like for example, even if the member pays extra money to the company should not send it to any other address. The letter has to be sent only to the registered address of the member and not to any other address at all. Okay, so this was about section 20. If I want to send a letter to the company or to the directors, I will send it to the RO address in 5 modes. If company wants to send any letter to the member or to the ROC, the company has all these options. But however, be careful. Like some documents have to be filed with ROC electronically only. So in all those cases, of course, we don't have all these options. But wherever the law is silent, in those places we have 6 options. Then lastly, we learned member can request the company send letter to me by this particular mode only, but company cannot request the member. And finally, we learned that whenever the company is sending any notice to the member, company should send it only to the registered address of the member. Even if the member pays extra money, still the company should not send it to any other address. Okay, now come, let's discuss some reminders from the prospectus chapter. See, shelf prospectus. We know that shelf prospectus has a validity period, guys. It has a validity period of 1 year. In this 1 year, the company can make one or more issues. Company can make any number of issues, but again and again, a prospectus is not required. The same prospectus itself will be valid for all the issues that the company makes in this 1 year period. But for all the subsequent issues, okay, fine. Again and again, prospectus is not required, but company, you at least have to prepare one information memorandum, right, guys? This information memorandum will contain 3 things. Number 1, it will contain details about the new charges created. It will contain details about the changes in the financial position of the company from the last prospectus till now and any other prescribed changes. So for all subsequent issues, the original shelf prospectus plus information memorandum put together will be deemed to be the prospectus. Simple points. What are the crucial points over here? Information memorandum will contain only the changes that have occurred since the shelf prospectus was issued. So since the shelf prospectus was issued, after that, were any new charges created? Since the shelf prospectus was issued, after that, was there any major change in the financial position of the company? So the changes since the shelf prospectus was issued, only those changes have to be mentioned in the information memorandum. And remember, this information memorandum also has to be filed with ROC, and for all subsequent issues, shelf prospectus plus information memorandum put together will be deemed to be the prospectus. Okay, then listen, some important points relating to private placement. Private placement offer can be made by the company to maximum 200% in a year. Please remember, this limit is per annum and it is per security, per annum per security. So every year this limit will get reset. For equity shares, separate 200% limit. Preference shares, separate 200% limit. So it's per year per security. Okay, when you're counting this 200% limit, you will exclude 2 people. You will exclude qualified institutional buyers. You will also exclude the employees to whom the company is offering ESOPs. Alright, then listen, this whole concept of 200 limit, the concept of 200 limit itself is not applicable to NBFCs and housing finance companies. Okay, now a question arises that what will happen if the company makes a private placement offer to more than 200 people? Then what will happen? In that case, guys, it will become a deemed public offer. It will be treated as if it's a public offer. Actually, it is private placement, but it will be deemed to be a public offer, and SEBI provisions and SCRA provisions will also start applying. Okay, then what are the time limits with respect to private placement that you should be aware of? See, once a company receives a share application money, company must allot the securities within 60 days. If the company is unable to allot within 60 days, then the company has to refund the money money within the next 15 days. If the company does not refund the money within these 15 days, the company will have to pay interest priced at the rate of 12% per annum. Okay, but what if the company was able to allot within 60 days? In that case, within the next 15 days, company has to file the return of allotment with the ROC within the next 15 days, and only after that only the company can start utilizing the money. So once the company receives the application money, within 60 days the company has to allot the securities. Once the company allots the securities, within the next 15 days file return of allotment. But if company is not able to allot the securities within 60 days, then company has to refund the money within the next 15 days. And if the company is not able to refund within these 15 days, then only 12% interest will apply. Okay, then listen to the next point. One more concept, one last concept in our prospectus discussion, guys. Underwriting. See, underwriting commission can be paid in money or it can also be paid in kind. So underwriting commission can be in the form of flats, it can be in the form of assets. It is allowed. It can be in money or it can be in kind. Then underwriting commission can be paid only for those securities which are being offered to the public, which means if the company is making a private placement offer, then in that case the concept of underwriting itself will not apply. Okay, so point number 1, underwriting commission can be in money or it can be in kind. Then point number 2, underwriting commission will be paid only with respect to those securities which are being offered to the public offer cases only. Okay, then underwriting commission company can pay only if it is authorized by the AOA. Now from where will the company pay this commission? What is the source of money? Company has 3 options. Either company can pay underwriting commission out of proceeds of the issue or out of the profits of the company, or using both. But the most important point, the most important reason why I am giving you this reminder is a limit. How much maximum underwriting commission can the company pay? It depends upon, are we paying underwriting commission for shares or are we paying underwriting commission for debentures? If the company is paying underwriting commission for shares, then the limit is 5% of the issue price or AOA rate, whichever is lesser. If the company is paying underwriting commission for debentures, then the maximum limit will be 2.5% of the issue price or AOA rate, whichever is lesser. Now, what mistakes are possible in the exam? Point number 1, mistake number 1, it is whichever is lesser and not whichever is higher. Point number 2, for shares we have a higher rate 5%, for debentures we have a lesser rate 2.5%. Mistake number 3, it is 5% of issue price, 2.5% of issue price, not face value. Okay, so tell me the limit once again. If it is shares, whether equity shares, whether preference shares, for shares the limit will be 5% of issue price or AOA rate, whichever is lesser. For debentures, 2.5% of the issue price or AOA rate, whichever is lesser. Company can pay underwriting commission only if it is authorized by AOA. Company can pay this out of the proceeds of the issue or out of the profits of the company, or both. Then a copy of the underwriting contract has to be filed by the company with the ROC along with the prospectus. You know, right? Every company, whenever it issues a prospectus, it has to file a copy of the prospectus with the ROC, guys. So when the company is filing a copy of the prospectus with the ROC, along with that the underwriting contract also has to be filed with the ROC. Okay, then in the prospectus we have to mention 3 things about underwriting. Who are the underwriters, the name of the underwriters, then what is the rate and amount of the underwriting commission, and lastly how many securities have been underwritten by each underwriter. There may be multiple underwriters, so name of all the underwriters, then how much commission are we going to pay to them, and how many securities each underwriter has underwritten. Okay, so this was your reminder about underwriting commission. Now come on, let's take some reminders from the share capital chapter. What I've done is the whole of section 54 I've brought over here, guys. See, sweat equity shares are nothing but shares given by the company to directors or to employees, either at a discount or for consideration other than cash, for providing know-how or making available rights in the nature of intellectual property rights or value addition by whatever name called. Point number 1, sweat equity shares are given by the company to whom? To directors and employees. Now, who are these employees? Who are these directors? See, employee means permanent employee of the company. That permanent employee may be working in India or may be working outside India. Then, the directors can be whole-time directors or part-time director, doesn't matter. So, we are giving sweat equity shares to whom? To employees of the company who are permanent employees, and we are giving sweat equity shares to directors of the company, whole-time, part-time, doesn't matter. But the interesting part, the important point is that we can give sweat equity shares not only to the directors and employees of the company, we can also give sweat equity shares to the directors and employees of the holding company, to the directors and employees of the subsidiary company. Even that is allowed. Whether they are working in India or outside India doesn't matter. So we can give sweat equity shares to whom? To directors, whole-time or part-time, doesn't matter, to permanent employees. These directors and permanent employees can be of the company, of the holding company, or of the subsidiary company, doesn't matter. Okay, then to issue sweat equity shares, a prior SR, a prior special resolution has to be passed. That special resolution will have validity period of 12 months only, which means within 12 months after passing the SR, the sweat equity shares have to be allotted. Okay, then sweat equity shares should be of a class which is already existing. In simple words, sweat equity shares cannot be a new class of shares altogether. It has to be a class which is already existing. Then there's a limit. How many sweat equity shares can the company issue? There are two limits. One is a per annum limit and the other is a total overall limit. Per annum limit is 15% of existing paid up equity share capital or 5 crore rupees, whichever is higher. And the overall limit depends upon is the company a startup or not a startup. If it's a startup, then the overall limit is 50% of paid up share capital, and for other companies, for non-startups, the limit is 25% of paid up equity share capital. Please notice over here, we use the word paid up equity share capital here, paid up equity share capital here, but for the 50% limit for startups, we just say paid up share capital. Small point, be careful. Okay, so lock-in period for sweat equity shares is 3 years, which means within these 3 years, the employee or the director cannot transfer the shares, cannot sell away the shares. Then the sweat equity shareholders will rank pari passu, which means they will have the same rights, same responsibilities, the same privileges which other equity shareholders have, no partiality. Then a very important point, guys, they have not tested this till now, be careful. See, the company is giving sweat equity shares to the employee or to the director. Now, in return, what is the company getting? In return, if the company is getting some asset, okay, so in that case, the company will recognize the asset in the balance sheet. Like for example, in return, if the company is getting some intellectual property from the employee, like if the company is getting some copyright from the employee, then in that case, company will pass the journal entry that asset, whatever asset the company got in return to share capital. Alright, and this asset will go into the balance sheet. But however, in return, if we are not getting an asset, in return, if you are getting some service from the employee, like for example, if the employee is saying that, listen, you give me sweat equity shares, in return, I am willing to work for you in a remote area, in a remote location. So in that case, we are not getting an asset from the employee. So in that case, what will you debit, guys? It will become an employee cost, which means your salary is expense, and this will become an expense for you in the P&L account. So in return, if you're getting an asset from the employee, you will put the asset in the balance sheet. But in return, if you're not getting an asset, then for example, if you're getting service from the employee, then that will become like your employee cost expense, like your salary expense, and it will be debited in the P&L account. Okay, then listen to one more point, a very important point. You have some time limit in ESOPs also. In ESOPs, you have the 1 year time limit, guys, and in these sweat equity shares, you have the 3 years time limit. Don't get confused, they're two different things. In ESOPs, 1 year is the minimum, it is a minimum 1 year time limit for vesting period. The vesting period has to be minimum 1 year, which means when did the company grant the option to you and when can you start exercising the option? In between gap has to be minimum 1 year. Sweat equity shares, 3 years time limit is the lock-in period, which means in these 3 years, the employee or the director, as a case maybe, cannot sell away the shares. Okay, so this was your entire discussion about sweat equity shares. So now come on everybody, let's do a revision of the revision, one final revision before you enter into the examination hall. See, when it comes to sweat equity shares, they are given to directors or employees. They have to be permanent employees, not temporary employees. Directors can be whole-time or part-time, doesn't matter. But who is directors? Who is employees? Companies, directors or employees? Holding companies or subsidiary company, everything allowed. Okay, then the sweat equity shares must be of a class which is already issued. A prior special resolution has to be passed. Special resolution will have validity period of 12 months. Within 12 months, the sweat equity shares must be allotted. Then what's the maximum limit for sweat equity shares? We have two limits, per annum limit and overall limit. The per annum limit is 15% of existing paid up equity share capital or 5 crores, whichever is higher. The overall limit depends upon is it a startup company or not a startup company. For a startup company, the overall limit is 50% of paid up share capital, and for non-startups, for other companies, the overall limit is 25% of paid up equity share capital. Then lock-in period 3 years. Then the sweat equity shares will also rank pari passu to other equity shareholders, which means they will have the same rights, same responsibilities, same privileges, same restrictions as the other equity shares. Then we have to see in return what did we get against the sweat equity shares. Accordingly only the accounting treatment will be done. In return, if we got an asset from the director or the employee, then we will capitalize the asset, put it into the balance sheet. But in return, if we don't get an asset, if for example we get some service in return, then that will become your employee cost expense and you will debit it in the P&L account. Okay. And then finally, we spoke about ESOPs and sweat equity shares comparison. We said ESOPs, you have 1 year minimum vesting period concept. In sweat equity shares, you have 3 years lock-in period concept. Okay. Now coming to section 67, one more reminder. Now this This one is relating to section 67. See, we know that section 67 says that a public company cannot give financial assistance to anybody to purchase its own shares or to purchase the shares of holding company. But there are three exceptional cases where a public company can give financial assistance. Number one, if it's a banking company, it can give financial assistance in the ordinary course of business. Now, even if the borrower uses the loan to buy the banking company's shares or the holding company's shares, it is fine, not a problem. Second point, the second exception, the public company can give financial assistance to trustee to purchase the shares of the company or to purchase the shares of the holding company for the benefit of the employees under employee share scheme. For this, there are some preconditions, but like precondition number one, how much maximum loan can be given? The maximum loan that can be given is 5% of paid up share capital plus free reserves. Condition number two, a prior special resolution has to be passed. And condition number three, the trustees have to use this financial assistance only to purchase the fully paid up shares of the company or the holding company, as the case may be. Then comes the third exception. In the third exception, the company is giving financial assistance directly to employees. But here again, I have three preconditions. Precondition number one, the employee should not be a director or KMP of the company. Precondition number two, maximum how much loan we can give them. Maximum up to 6 months of their salary or wages we can give them as financial assistance. And condition number three, the employees should be using this financial assistance only to purchase fully paid up shares of the company or of the holding company. Okay. Still clear till here? So giving you a revision of the revision once again, under section 67, generally a public company cannot give financial assistance to purchase its own shares to anybody. But however, under section 67, there are three exceptional cases. In those three exceptional cases, a public company can give financial assistance. Number one, if it's a banking company, it can give financial assistance in the ordinary course of business. Number two, a public company can give financial assistance to trustees to purchase fully paid up shares of the company or holding company. Maximum loan that can be given here is 5% of paid up share capital plus free reserves. Now the trustees will use this loan to purchase fully paid up shares of the company or holding company for the benefit of the employees. But here prior SR is required. And lastly, the public company can give financial assistance to its employees other than directors, other than KMP, maximum 6 months of their salary or wages. And even over here, the employees will use this financial assistance only to purchase a fully paid up shares of the company or holding company. Easy, guys. Now listen, there's one more point over here that you should be aware of. See, section 67 is not applicable to redemption of preference shares. Also, section 67 is not applicable to private companies, which means private companies can freely give financial assistance to purchase their shares or to purchase the shares of their holding company. Private companies, no restriction. But for private company, there will be no restriction only if the private company fulfills four conditions. Condition number one, that private company should not have any default in filing financial statements and annual return. Then condition number two, that private company, in that private company, no other body corporate should have invested any money in the capital. Which means, if you look at the shareholders of this private company, all the shareholders should be individuals or non-companies. Basically, no other body corporate, no LLP can be a member of this private company. Then number three, you will look at the total borrowings of this company from three people. Total borrowings from banks, from financial institutions and from other body corporates put together. The total borrowing should be within the limit. No, it should be less than the limit. What is the limit? The limit is 2 times of paid up share capital or 50 crores, whichever is lesser. And condition number 4, this private company should not have any subsisting default with respect to repayment of these borrowings. So there are 4 conditions. If all the 4 conditions are fulfilled by a private company, that private company can freely give financial assistance to purchase its shares or to purchase the shares of its holding company. No conditions, no restrictions, nothing. Okay, tell me the 4 conditions one last time. Condition number 1, no default in filing financial statements or annual return with the ROC. Then condition number 2, no other body corporate has invested in the equity of this company. Then number 3, condition number 3, if you look at the total borrowings of this company from bank, financial institution and body corporates put together, it is less than the limit. The limit is 2 times of paid up share capital or 50 crores, whichever is higher. Whichever is lesser. And lastly, there is no subsisting default with respect to repayment of these borrowings. Okay. So this was our entire reminder relating to section 67. Now before I close the share capital chapter, one more reminder I want to give you. Who cannot be appointed as debenture trustee? The law does not say who can be debenture trustee. The law says who cannot be debenture trustee. So we have 7 disqualifications. If a person fulfills any of the 7 disqualifications, then that person cannot be appointed as debenture trustee. Now, what are the 7 disqualifications? Number 1, any person who beneficially holds shares in the company, which means, see, whether you're a registered member of the company or not doesn't matter. But if you have beneficial ownership in the company, then you cannot be appointed as a debenture trustee. Then, promoter, director, KMP, officer, employee of cash can't be appointed as debenture trustee in the company. Then, their relatives. Then, any person who owes money to the company or any person to whom the company owes money, they can't be appointed as debenture trustee. Then any person who has furnished guarantee to the debenture holders that don't worry, company will repay the debentures. If company doesn't repay, I will repay. So if any person has given guarantee like that to the debenture holders, then the guarantor can't be appointed as debenture trustee. And lastly, any person who has pecuniary relationship with the company. Pecuniary relationship means he's having monetary relationship more than a certain limit. What is the limit? 2% of the gross turnover or total income or 50 lakhs, whichever is lesser. So any person who fulfills any of the 7 disqualifications, that person cannot be appointed as debenture trustee. The most important is the first one over here. Remaining you will be able to handle. See, the first one says any person who beneficially holds shares, which means whether you are a registered member of the company or not, I don't care. If you have beneficial interest in the shares, if you have beneficial ownership in the shares, then you cannot be appointed as debenture trustee. Then one more important point, remember, if you owe money to the company or if the company owes money to you, it can be 100 rupees also, doesn't matter. Even if it is a small amount, doesn't matter. If you owe money to the company or if the company owes money to you, then you cannot be appointed as debenture trustee. Okay. Then one more point, guys. See, whenever the company has made a mistake in the register of members, like for example, let's say there's a particular person, he's a member of the company, but by mistake the company has not put his name in the register. Or let us say there's a person, he's actually not a member of the company, but don't know why company has put his name in the register. So to rectify the register, we can make an application to NCLT, guys, under section 59. So when NCLT passes an order asking the company to rectify the register of members, the company has to rectify within 10 days. So I want you to remember this time limit, very unique time limit, guys, within 10 days. When understand the situation, right? The situation is that company has made a mistake in the register of members. Either company has by mistake omitted the name of a member, or the company has by mistake inserted the name of a non-member in the register. So we can make an application to NCLT and request NCLT to ask the company to rectify the register. In that case, if NCLT passes an order asking the company to rectify the register, then the company must rectify the register within 10 days. That's all. Easy. Okay. Now coming to the deposits chapter, I want to first discuss with you over here the maximum limit. That how much maximum can the company accept as deposits. We'll discuss everything. How much can the company accept maximum from the members? Then we will discuss how much the company can accept maximum from the public. And then we will discuss for short-term requirement maximum how much can the company accept as deposits. There are only 3 limits in the deposits chapter. All the 3 we'll talk about. First, talking about members. Every company can accept deposit from members, but there's a maximum limit. The maximum limit depends upon what kind of a company is it. Like for example, if it's a private company, it can accept maximum 100% of paid up share capital plus free reserves plus securities premium. And when I say maximum, I'm not talking about just the deposits to be accepted in the current year. Whatever outstanding deposit the company already has, plus the deposits to be accepted now, everything put together should not exceed this limit. Okay. Then if it's an eligible company, the eligible company can accept from the members up to 10% of paid up share capital plus free reserves plus securities premium. All other companies which are not private companies, not eligible companies, for them the limit is 35%. So easy, guys. So if the company wants to accept deposit from the members, then if it is a private company, the limit is 100% of paid up share capital plus free reserves plus securities premium. If it is an eligible company, here the limit is going to be 10%. And if it is any other company, the limit is going to be 35%. Okay, now listen to me. If it is a private company, then this limit of 100% itself will not apply. Which means if it's a private company, it can accept deposits more than this 100% limit also if that private company comes under any one of these 2 categories. I've put the word or in between, which means if the private company comes under any one of these 2 categories, then this 100% limit is not applicable. That private company can accept how much ever deposit it wants from the members. What are the 2 situations? Situation number 1, it's a startup company and 10 years have not gotten over since date of incorporation. So if it's a startup company, for the first 10 years after the date of incorporation, the limit will not apply. Then situation number 2, the company is not an associate company, it is not a subsidiary company of another company, and So condition number 1, not a subsidiary, not an associate. Condition number 2, the total borrowings from 3 persons. Who are the 3 persons? Same 3 persons which we saw in section 67, guys. Bank, financial institutions, body corporate put together is less than the limit. Same limit which we saw over there. 2 times paid up share capital or 50 crores, whichever is lesser. This is your condition 2. And condition 3, there is no default in the repayment of these borrowings. Very easy. Same 2 conditions you have in section 67 also. Same 2 conditions you have in private company exception also. So if your private company is either a startup and it is within the first 10 years, or your private company is neither associate company nor subsidiary of another company and its borrowings are less than the limit and there is no subsisting default also, then in that case, for these private companies, the 100% limit is not applicable, which means these companies can accept deposits more than the limit also. But however, if they do that, they at least have to file, the details of the money so accepted with the ROC. Okay, fine, they can accept deposits more than the limit, but they still have to inform the ROC about it. Okay, so this was about our discussion about accepting deposits from members. Now coming to the next discussion, what if your company wants to accept deposits from public? See, we know very well only eligible companies can accept deposits from the public. So eligible companies can accept deposits from the public maximum 25% of paid up share capital plus free reserves plus securities premium. But if that eligible company happens to be a government company, then government companies can accept deposits from the public up to 35% of paid up share capital plus free reserves plus securities premium. Okay, now whatever limits we have learned over here, these are the limits if the company wants to accept deposits for long term. Long term means what? The tenure will be anywhere between 6 months to 36 months. Okay. But in case a company wants to accept deposits for short term would be company wants to accept deposits for anywhere between 3 months to 6 months. In this case, whether the company is accepting from members, whether the company is accepting from public doesn't matter. Only one limit we have, and the limit is 10% of paid up share capital plus free reserves plus securities premium. Understanding, guys? That's all. So this is my entire discussion about the limits, that maximum how much company can accept as deposits from the members. If it's a private company, then 100%. If it's a public, if it's an eligible company, 10%, and other company 35%. Percentage of what? Paid up share capital plus free reserves plus securities premium. Then we learned if it's a private company and if this private company comes under any of these 2 buckets, then for that private company the limit will not apply, but it should still inform the ROC about it. And then we spoke about accepting deposits from the public. If you are accepting deposits from the public, eligible company maximum limit is 25%. If the company is a government company, then the limit will be 35%. Okay, so this was your reminder number 12. Now coming to reminder number 13, who is an eligible company? Eligible company is a company which fulfills 4 conditions, guys. Condition number 1, it should be a private company. Condition number 2, net worth should be at least 100 crores or turnover should be at least 500 crores. So if you see, an eligible company is a company which condition number 1 second. So condition number 1, it should be a public company. Condition number 2, either the net worth should be at least 100 crores or the turnover has to be at least 500 crores. Okay. Condition number 3, listen carefully. If the company is accepting deposits within section 181C limit, then in that case, ordinary resolution has to be passed in the general meeting of the company. If the company is accepting deposits more than section 181C limit, then in that case, a special resolution has to be passed in the general meeting of the company. Condition number 4, if special resolution was passed, then a copy of the special resolution has to be filed with the ROC. So that public company which fulfills all these 4 conditions will become eligible company, and only if you're an eligible company you can accept deposits from the public. Okay, so condition 1, public company. Condition 2, net worth at least 100 crores or turnover at least 500 crores. Condition number 3, if you're accepting deposits within 181C limit, then only OR is required. If you're accepting deposits more than 181C limit, then SR is required, and if SR is passed, that has to be filed with ROC. Alright guys, easy. Now listen, come to my next point. My next set of reminders are about the charges chapter. 2 reminders I want to give you over here. One is Section 77, the most important section in your charges chapter, and then I also want to give you a reminder about the types of charges. Okay, let's talk about section 77 first. See, section 77 talks about the time limit, that within how much time we are supposed to register the charge. We know very well that once a charge is created, thereafter this charge has to be registered with the ROC, guys, because only when the charge is registered, only then the charge will become only then the charge will be valid. If we don't register the charge, then we will treat as if there is no charge itself. The charge will become void. So therefore the charge has to be registered with the ROC by the company. Now within how much time limit? It all depends upon the date of creation of charge. So whatever is the date of creation of charge, from that date, within 30 days itself, the charge has to be registered with the ROC. In that case, we have to pay fees. But in case the company is unable to register within these 30 days, it's okay, company. You can register within 60 days from the date of creation. That means you can register in the next 30 days. But in this case, company, you will have to pay additional fees. But if the company is unable to register within these 60 days also, then company, you can register in the next 60 days. But in this case, you will have to pay ad valorem fees. Ad valorem fees means the fees is not fixed. The fees will depend upon the value of the charge. That is, the fees will depend upon the amount of the loan against which the asset has been given as security. Understanding? So the general time limit is 30 days. Company, you must complete the registration of charge within 30 days from the date of creation. If you are unable to do that, you can do the registration within 60 days from the date of creation. But in that case, you will have to pay additional fees. Then if you are unable to do the registration within these 60 days also, it's okay. You can register within the next 60 days, and in that case you will have to pay ad valorem fees. Ad valorem fees is nothing but fees which is a percentage of the value of the charge. Value of the charge means what? Value of the charge is not the value of the asset, guys. Value of the charge is the amount of the loan. How much loan has a lender given you against the charged asset? So the amount of the loan, that into the specified percentage will become your ad valorem fees. Okay, this was your reminder number 14 about section 77. Now talking about the different types of charges, see, we know very well that there are two types of charges. One is fixed charge and the other is floating charge. In fixed charge, we are giving permanent assets, that is fixed assets as security. Like for example, land and building, plant and machinery, we are giving fixed assets as security. The company can continue to use the asset, just that the company cannot sell away the asset. If the company wants to sell the charged asset, company will require the charge holder's permission. Simple, guys. So if you talk about fixed charge, company is giving permanent assets as security. Company can continue to use the asset, just that the company cannot sell away the asset. But if the company wants to sell the charged asset, it can sell with the charge holder's permission. Okay. But when you talk about floating charge now, in floating charge, company is giving current assets as security, like your stock in trade, your inventory, your bank balance, the debtors. Company is giving floating assets, fluctuating assets, current assets as security in floating charge. In floating charge, company can use the asset also, company can sell away the asset also, no problem at all. Alright, but however, there are some situations where this floating charge will get crystallized. Crystallized means the floating charge will get converted into fixed charge. Now, if it gets converted into fixed charge, in such cases what will happen is the company can neither use the asset nor can the company sell away the asset. The lender will simply take over the asset to realize the loan. Okay, so this is called as crystallization of charge. Now, when will this happen? This will happen in three situations. Number one, when the company violates the terms and conditions of the charge. Number two, when the company winds up. And number three, when the creditors enforce the security. Okay, but always remember, whether it is fixed charge, whether it is floating charge, doesn't matter. Both the charges have to be registered with the ROC. Okay, so we spoke about the two types of charges. Fixed charge you've understood properly. Floating charge, remember, company is creating a charge on the fluctuating assets, on the current assets. Company can continue to use the asset. Company can also sell away the asset. No need charge holder's permission, nothing. But however, there are three extreme cases where that floating charge gets converted into fixed charge. That is called as crystallization of charge. When that happens, the company can neither use the asset nor can the company sell away the asset. Instead, the asset will simply be taken over by the lender for realization of the loan. When will that crystallization happen? What are the three extreme situations? Number one, when the company violates the terms and conditions. Number two, when the company winds up. And number three, when the creditors enforce security. Okay, now coming to our management and administration chapter. Here, first of all, I want to give you a nice solid revision of the whole quorum concept, guys. Section 103. Quorum is nothing but the minimum number of members who must be personally present at the meeting. Only then the company can validly constitute the meeting. Only then the company can transact business at the meeting. Okay. Now this quorum should be present within how much time? Within half an hour of the appointed time. What if the quorum is not present within half an hour? Then we'll have to check, is it a meeting which the board of directors has called, or is it a meeting called by requisitionists? See, if it is a meeting called by requisitionists, and in that meeting, if the quorum is not present within half an hour, then the meeting itself will stand cancelled. No question of adjourning the meeting, it will stand cancelled. But guys, if it's a usual general meeting, usually general meeting is called by the board of directors, right? So in that general meeting, if quorum is not present within half an hour, then it's okay, we will adjourn the meeting. The meeting will get adjourned to either same day, same time, same place in the next week, or it will get adjourned to some other date or time which the board of directors will decide. Now the question arises that for this adjourned meeting also, does a notice have to be given? Yes. 21 days notice? No. Only 3 days notice has to be given for this adjourned meeting also. Now either this adjourned meeting notice has to be given to each member individually, or if it's too much of a hassle, company can simply give it as an advertisement in 2 newspapers, one English newspaper and one vernacular newspaper, having wide circulation in the place where the RO is situated. Okay, so now in the adjourned meeting also, what if there is no quorum? In the adjourned meeting also, if there is no quorum, then we can't help it. In that case, how many of our members are personally present? We'll assume that itself is quorum and we'll go ahead with the meeting. Okay, so understood, right? Quorum should be present within half an hour from the appointed time. If it is not present within half an hour, you will see what kind of a meeting is it. Is it a general meeting which is called by the board, or is it a general meeting which is called by the requisitionist? If it's a meeting called by requisitionist, no question of adjourning the meeting, it will simply get cancelled. But if it's a general meeting called by the board of directors, it will get adjourned either to same day, same time, same place in the next week, or any other date, time or place which the board will decide. Now for that adjourned meeting also, we have to give 3 days notice. Either the notice has to be sent to each member individually, or we can simply publish it as an advertisement in one English newspaper and one vernacular newspaper. But what if in the adjourned meeting also there is no quorum? Then in that case, we can't help it. How many of our members are present? We'll assume that itself is quorum and we'll go ahead with the meeting. Okay, now always remember, quorum should be present not only when we begin the meeting, it should also be present throughout the meeting. So see, if quorum is not even present, we can't even start the meeting. But let us say quorum is present at the time of starting the meeting. Now after that, some members left. If the number of members who are present is less than the quorum at the time of any discussion, then that discussion can't happen. So quorum should be present not only when you begin the meeting, it should also be present throughout the meeting. Okay. Now, how much is this quorum? It depends upon what kind of a company. In a private company, quorum is 2 members, very simple. But in a public company, the quorum depends upon how many members are there in the company. If the company has up to 1000 members, then the quorum will be 5. If the company has more than 1000 but up to 5000 members, then the quorum will be 15. If the company has more than 5000 members, then the quorum will be 30. Okay. Now, when you're counting this quorum, whom will you consider and whom will you not consider? See, members who are personally present, will you count them? Yes guys, quorum is nothing but the members who are personally present. So we will count the members who are personally present. But will you count the proxies? No, proxies will not be counted because we're only counting the members who are personally present. Okay, then persons who are representing corporate shareholders, we will count them because a corporate shareholder by itself anyways can't come and attend the meeting. The corporate shareholder anyways has to send a representative. So when the representative comes, it is as if the shareholder himself has come. So the person representing corporate shareholder, similarly the person representing president and governor, they will be counted in quorum. Then preference shareholders, will you count them? It depends. If they have voting right, you will count them. But if they don't have voting right, then you will not count them in quorum. Okay. Then members who are personally present but they cannot vote because he is a related party for a business, even such persons will be counted as quorum. Member is personally present, but that member is a related party. That's why that member does not have voting power for one particular matter, let us say. Still, that person will be counted in quorum. Then the most important point, a member who has already voted electronically, alright, can he attend the meeting? Yes. Can he vote again at the meeting? No, he can't vote again at the meeting. Will he be counted in quorum? Yes, he will be counted in quorum. Understanding, guys? So this was our discussion, a quick reminder of the quorum point. The last point was very important. I hope you paid attention. If a member has already voted electronically, he can attend the meeting. He can't vote again at the meeting, but he can attend the meeting. But in this meeting, when we're checking whether quorum is there or not, we can count him also. Member who is personally present but cannot vote, as he has already voted electronically, even he will be counted in quorum. Okay guys, this was a quick reminder of a quorum discussion, section 103. Now coming to annual return, section 92. See, every company has to file annual return with the ROC within 60 days from the date of the AGM. See, don't get confused. Every company has to file financial statements with the ROC and every company has to file annual return with the ROC. The time limit for both starts from the date of the AGM. The financial statements have to be filed from the date of AGM within 30 days guys. The annual return has to be filed from the date of AGM within 60 days. So from the date of AGM within 60 days, the company has to file annual return with the ROC. But what if the company is not conducting the AGM? It's okay. We will see what is the last day by which the company should have conducted the AGM. From that last day, we will count 60 days. Within 60 days, company must file the annual return with the ROC. Okay. Now this annual return has to be signed by whom? That depends upon what kind of a company is it. Is it a one-person company or a small company or a private company which is recognized as a startup? So if the company happens to be any of these three companies, then in that case the annual return will be signed by the company secretary, and in case the company does not have a company secretary employee, in that case the annual return will be signed by a director of the company. Okay, now if the company is not any of these three companies, if it is any other company, then in that case the annual return will be signed by two people, by the company secretary and by the director. Okay, but again the same question will arise, what if the company does not have a company secretary employee? In that case, we will go to a practicing company secretary and get signature from him. Okay, so annual return has to be filed by every company with the ROC within 60 days from the date of the AGM. In case the company does not conduct the AGM, then we will see what is the last day by which the company should have conducted the AGM. From that date, within 60 days, we are supposed to file the annual return with the ROC. Then annual return will be signed by whom? If it's a one-person company, small company or a startup, it has to be signed by company secretary. If no company secretary, then by a director. For other companies, it has to be signed by company secretary and director. If no company secretary, then by a practicing company secretary. Okay. Now, what should be the form of annual return? See, if it's a one-person company or a small company, the abridged form of annual return is applicable, which is form MGT7A. For other companies, it is MGT7. Okay. So this was your reminder number 17. Now coming to reminder number 18, the last reminder, no, not the last reminder, the second last reminder in your management and administration chapter. Special resolution. See, listen, ordinary resolution means what? And special resolution means what? Ordinary resolution means the number of votes in favor should be more than the number of votes against. Special resolution means the number of votes in favor should be at least 3 times the number of votes against. Okay, if a special resolution has to be passed, then in that case, in the notice, it must be clearly mentioned that for this particular matter, SR will be required. Okay, it has to be mentioned in the notice. And once SR is passed, within 30 days, a copy of the SR has to be filed with ROC. Now, when we are checking the number of votes, when we are counting the number of votes, we will not consider invalid votes. We will not count the members who have not even voted. We will only see how many votes are in favor. We will only see how many votes are against. Okay, like over here in my example, if you see, we have 5 votes against. So 3 into 5 is 15 guys, and number of votes in favor is 20. So is 20 more than or equal to 15? Yes, hence you will conclude that SR has been passed. Okay, so special resolution, you will not simply write 3/4, you will not simply write 75%, you will write special resolution means number of votes in favor is at least 3 times the number of votes against. Okay. Then after this, one last concept in our management and administration chapter, report on AGM section 121. See, this concept is applicable only to AGM and not to EGM. Okay, once the AGM is over, after that, within 30 days, one report has to be prepared and filed with the ROC. See, just like how we prepare minutes of the meeting, minutes anyways has to be prepared, even this report on AGM also has to be prepared. Even the minutes will contain fair and correct summary of the proceedings, guys. Even this report will also contain the fair and correct summary of the proceedings of the AGM. We will write in this report that when was the meeting held, who was the chairperson, how many members attended, whether the quorum was present or not, what matters were discussed in the meeting, did the meeting require any adjournment, whether the meeting was conducted as per the provisions of the Companies Act, the corresponding rules, as per the secretarial standards. All this will be written in this report, and this report will be submitted to the ROC within 30 days of the conclusion of the AGM in form number MGT 15. Okay, but the point is, this concept is not applicable to every company. It is applicable only to listed companies. So which means, can I say in listed companies, once a meeting is concluded, two things will be prepared. Minutes book will any case be prepared. This report on AGM also will be prepared. Minutes book does not have to be filed with ROC and all. Company will just prepare the minutes book and keep. But this report on AGM has to be filed with ROC in form number MGT15. Okay. Now this report, this MGT15 has to be signed by whom? This is important. It has to be signed by the chairperson of the meeting. In case a chairperson is unable to do the signing, then in that case it will be signed by any two directors, one of whom shall be managing director, and by the company secretary of the company. So chairperson has to sign. If the chairperson is unable to sign, then in that case two directors will sign. Out of them, one has to be managing director and the company secretary will sign. Okay guys, so this is about a report on AGM. Remember, this concept is not there in EGM, it's only in AGM. Within 30 days after the conclusion of the meeting, this report has to be prepared and it has to be filed with ROC. Even this report contains fair and correct summary of everything which happened in the AGM, form number MGT15. It has to be signed by the chairperson. If the chairperson is unable to sign, then it has to be signed by two directors, out of which one has to be managing director, and it has to be signed by the company secretary also. Okay, now see, I'll give you one quick summary over here. Listen to me. We're going to talk about the signing part. Annual return has to be signed by whom? If it's a one-person company, or if it is a small company, or if it is a private company which is recognized as startup, then it has to be signed by company secretary. If company has no company secretary, then in that case it has to be signed by the director, guys. If it is any other company, then it has to be signed by company secretary and by the director. If the company does not have company secretary, then we will go to a practicing company secretary and get signature from that person. Now coming to your report on AGM, your MGT15. Now this report has to be signed by whom? It has to be signed by the chairperson of the meeting. If the chairperson is unable to sign, then it has to be signed by two directors, one of whom will be managing director, and it has to be signed by the company secretary. Okay guys, so this is about the signing part. I just wanted to give you a quick summary so that there is no scope for confusion. Okay, so under our management and administration chapter, 5 points or 4 points we have revised. One is the whole of quorum discussion. Remember, in quorum guys, member who has already voted electronically, he can attend the meeting. He can't vote again at the meeting, but he will be counted in quorum. And by the way, tell me, can this person appoint proxy? A member who has already voted electronically, he can attend the meeting, no doubt. We are also counting him in quorum. This person can't vote again at the meeting, but can he appoint proxy? He cannot appoint proxy, guys, because only that member can appoint proxy who has the right to vote at the meeting. Only that person can appoint proxy. Now, this member does not have the right to vote at the meeting, right? Because he has already voted electronically. So, this person can't appoint proxy. Okay. And then we spoke about annual return, special resolution calculation, and report on AGM. Okay, now come on, let's move on to our next discussion. Let's talk about dividend. See, first of all, talking about final dividend, whether the AOA authorizes or not doesn't matter. Every company can declare final dividend. Final dividend is always declared in the AGM, guys, and there are two steps. It is first recommended by the board, and then it is approved by the shareholders in the AGM by passing ordinary resolution. Once a company declares final dividend, it cannot be revoked. Only in extraordinary cases like fire and all, it can be revoked with the consent of all the members. Okay, but on the other hand, interim dividend company can declare only if it is authorized by the AOA. Interim dividend is never declared in the AGM. It always declared outside the AGM. Here the shareholders have no role to play. It is straight away declared by the board of directors itself. And interim dividend can be revoked with the consent of all shareholders. It can be revoked. Okay, now once a board declares dividend, the shareholders cannot bargain. They cannot increase the rate of dividend. They cannot insist on dividend. They can, however, lower the rate, but they cannot increase the rate. Okay, this was one small point with respect to dividend. Now, one more reminder, guys, if the company has committed any default with respect to deposits, or if the company is a Section 8 company, then in these two cases, company is prohibited from declaring dividend. So, two prohibitions: either the company has committed any default with respect to deposits, or if the company is a Section 8 company, then in that case, that company cannot declare any dividend. Okay, now there are some important time limits with respect to dividend that I want to give you a reminder of. Listen to me. Once a company declares dividend, the company will deposit the dividend in a separate bank account within how much time time in a separate bank account within 5 days. Okay, within 5 days from the date of declaration. Then once a company declares a dividend, the company actually has to pay the dividend. The company actually has to post the dividend warrant within 30 days from the date of declaration of dividend. Then once 30 days are over, even after that, if the company is still having unpaid or unclaimed dividend, within 7 days from the expiry of the 30 days, that unpaid dividend will be transferred into unpaid dividend account. In case there's any delay in doing that, company will have to pay 12% per annum interest the company will have to pay. Now once the unpaid dividend goes into the unpaid dividend account, from that account can the shareholder come and claim the dividend money? Yes, he can claim. Okay. Then once a dividend goes into the unpaid dividend account, within 90 days itself, company will prepare one list. That list will contain 3 things: the name of the shareholder to whom the unpaid dividend belongs, then his last known address, and what is the amount of unpaid dividend that belongs to him. So company will prepare a list containing these 3 details, and that list will be uploaded onto the company's website and other websites as required by central government. Then once the money gets transferred into the unpaid dividend account, the money will stay there maximum for 7 years. Within 7 years also, if the member does not come and claim the money from the unpaid dividend account, then once 7 years are over, the entire unpaid dividend amount along with interest which has accrued in that bank account, everything will be taken and sent off to IEPF after the expiry of 7 years. Okay. Then remember, in case let's say last 7 years, let's say right now we are in year 8. So we'll look at year 1 to year 7. In all of these years, for example, the company had declared dividend. But last 7 years, all of these 7 years, that shareholder has not even claimed any dividend, guys, last 7 years. In that case, those shares itself will get transferred into IEPF. Okay, so some 5 to 6 time limits only we have. First time limit is 5 days. Once a company declares dividend, the company has to set aside the entire money in a separate bank account within 5 days from the date of declaration of dividend. Then your second time limit is 30 days. From the date of declaration of dividend, within 30 days, company should actually pay the dividend or post a dividend warrant. Then point number 3, even after 30 days, if the company still has any unpaid or unclaimed dividend, then within 7 days after the expiry of the 30 days, the company is to transfer the unpaid dividend into unpaid dividend account. Then point number 4, if the company delays in transferring this money into unpaid dividend account within 7 days, then 12% per annum interest the company will have to pay. Then comes point number 5, once a company transfers the unpaid dividend into unpaid dividend account, within 90 days, company will have to prepare a list containing these 3 things, and the list has to be uploaded onto the company's website. Then point number 6, once the money is transferred into the unpaid dividend account, it will stay there only for 7 years. Within 7 years also, if the member does not claim the money, then in that case the unpaid dividend along with the accrued interest will be transferred to IEPF. And lastly, guys, if for a particular share dividend has not been claimed for any of the last 7 years, then those shares will also get transferred into IEPF. Okay, so this was our entire discussion about the time limits that I wanted to give you a revision of. And tell me, the dividend, let's say the dividend has been transferred to IEPF, or let's say the shares have been transferred to IEPF. Now can the shareholder claim all this from IEPF, guys? Yes, he can claim all this from IEPF. Okay. Then listen, coming to the next point, section 127, extremely important. Listen, see, in case a company has committed a default, what default? Company has declared the dividend, but the company is not making the payment within 30 days. Just now we learned, right? From the date of declaration, within 30 days, company is supposed to pay the dividend. But if the company is not paying the dividend within 30 days, or if the company is not posting the dividend warrant within 30 days, then in that case, heavy punishment, guys. The punishment, first of all, who will be punished? The directors of the company who are unknowingly a party to the default will be punished, and the company will also be punished. For the directors, if you see, they will be punished with imprisonment and fine. Imprisonment will be maximum 2 years. Fine will be minimum 1,000 rupees per day. The most unique part about this punishment is that there is no maximum limit. We're just saying fine is minimum 1,000 rupees per day. There's no upper limit. Okay, so directors will be punished with maximum 2 years imprisonment and fine. Fine is minimum 1,000 rupees per day of delay, no upper limit. Company will have to pay 18% per annum interest. Okay, but however, if the company did not pay dividend within 30 days, why? If the reason is any of these 5 reasons, then in that case, even though the dividend was not paid within 30 days, still no punishment. What are the 5 reasons? Reason number 1, dividend could not be paid because of operation of law. Then reason number 2, the shareholder had given some instructions to the company. Those instructions cannot be complied with, and the company has also informed the shareholder about it. Then point number 3, there's some dispute going on that who has a right to get the dividend from the company. Then number 4, the shareholder owes money to the company and the company has lawfully adjusted the dividend money against the amount which the shareholder owes to the company. And lastly, any other reason which is not the company's fault. So if the company has not paid dividend within 30 days and the reason is any of these 5 reasons, then in that case no punishment under section 127. Otherwise, hefty punishment guys. Directors will be punished with maximum 2 years imprisonment and fine minimum 1000 rupees per day and company 18% per annum interest. Okay, so this was about our dividends chapter. Now coming to some reminders from the accounts of companies chapter. See, we know very well that financial year has to be 12 months from April to March guys. But however, if the company is incorporated in Jan, Feb or March, then the first financial year will end not on the coming 31st March, but it will end on the next 31st March, because of which the first financial year can be up to 15 months long. Right guys, similar provision we have in LLP also, but in LLP the provision is a directory provision. We have the word may. In LLPs, if the LLP is incorporated between October to March, then the first financial year will not end on the coming 31st March, it will end on the next 31st March. So in LLPs, if you see, the first financial year can be maximum 18 months long also. Okay. Now coming back to my Companies Act, imagine a situation where there's an Indian company has to follow the financial year April to March generally. Now let us say this Indian company happens to be the holding company or a subsidiary company or an associate company of a foreign company. Okay. Now for this foreign company, let's say the financial year happens to be Jan to December. Now consolidated financial statements have to be prepared, and the Indian company is following a different financial year, the foreign company is following a different financial year. It will be very difficult in such cases to prepare consolidated financial statements. So in such cases, this Indian company can file an application to the central government and can request the central government that please let me also follow Jan to December in our example. If the central government is satisfied, central government will allow this Indian company to follow a different financial year. Okay, otherwise April to March only. Only if the Indian company happens to be a holding company, subsidiary company or associate company of a company incorporated outside India, and for the purpose of consolidated financial statements, if a different financial year is being followed outside India, then in that case, that Indian company can make an application to the central government, not NCLT, central government, and request central government that please let me follow a different financial year. If central government is satisfied, central government will allow the company to follow a different financial year. Okay. Then talking about internal audit is mandatory not for every company. It is mandatory only for those companies which fit under any of my 3 buckets. What are my 3 buckets? Number 1, listed company. Number 2, and those unlisted public companies which fulfill any of these 4 criteria. Either the paid up share capital should be at least 50 crores in the preceding financial year, or the turnover should be at least 200 crores in the preceding financial year, or the outstanding loans or borrowings from banks and financial institutions should be more than 100 crores at any point of time in the preceding financial year, or the outstanding deposits should be at least 25 crores. So if unlisted public company fulfills any of these 4 criteria, then for that company internal audit will be mandatory. Please notice, outstanding loans and borrowings should be more than 100 crore at any point of time in the preceding financial year, not necessarily at the end of the financial year. Okay. Then comes the third category. The third bucket is private company. Very easy guys. The same second and the third points here also. So turnover has to be at least 200 crores, or outstanding loans and borrowings from banks and financial institutions should be more than 100 crores at any point of time in the preceding financial year. So if your company fulfills any of these 3 criteria, for that company internal audit will be mandatory. Okay. Now if internal audit is mandatory, internal auditor can be a CA, CS, a cost accountant, or any professional as decided by the board of directors. Members don't appoint internal auditor. It is a board that appoints an internal auditor. So internal auditor can be a CA, a cost accountant, or any other professional, may or may not be employee of the company, may or may not be practicing, doesn't matter. But however, remember, the statutory auditor of the company cannot be appointed as internal auditor neither in the company, nor in the subsidiary company, nor in the holding company. Like for example, let's say there's a company A Limited. Okay, and this A Limited has a subsidiary company S Limited, and A Limited also has a holding company H Limited, let us say. Now if I am a statutory auditor in A Limited, let us say, if I'm a statutory auditor here, then I cannot be internal auditor in the holding company. I cannot be internal auditor in the in the company itself, I cannot be internal auditor in the subsidiary company. Okay, so statutory auditor cannot be internal auditor of the company, subsidiary company or holding company, not allowed. All right, guys, I'm stressing upon that same point once again. Don't forget, outstanding loans and borrowings point should be more than 100 crores at any point of time in the preceding financial year. Even the deposits point at least 25 crores at any point of time in the preceding financial year. Okay, don't forget that. Now coming to the next concept under accounts of companies, very important, guys. It's been a very long time since they have asked this director's responsibility statement. See, the board of directors prepare a board report, right? In the board report, one of the contents is director's responsibility statement. So over here, the directors are stating that they have fulfilled all these responsibilities. Total 9 points. The hint for you to remember will be 4 A's and then FICGJ. If you look at your ICA study material, these 9 points are given as 4 big paras. Will become difficult to study. I have just broken them down into 9 points. So, director's responsibility statement, it's a part of the board report. In this statement, the directors are saying that they have fulfilled 9 responsibilities. What are the 9 responsibilities? First, I have 4 A's. Number 1, proper accounting standards have been followed. In case there is any departure, then explanation has been given. Second A, the directors have selected the accounting policies and they are not changing the accounting policies. They are applying the accounting policies consistently. Then number 3, proper and sufficient care has been taken in maintaining accounting records. Then the last A, the directors have taken proper and sufficient care in safeguarding the assets of the company. So we spoke about 4 A's. The first A is that accounting standards have been followed. The second A is that accounting policies are being applied consistently. Then number 3, accounting records, proper and sufficient care is taken in maintaining adequate accounting records. And number 4, proper and sufficient care is taken in safeguarding the assets of the company. Okay, so these are the first 4 A's. Then we have 5 more responsibilities of the directors, and that is FICGJ. F stands for fraud. Proper and sufficient care has been taken by the directors in preventing and detecting frauds in the company. Then I stands for internal financial controls. The directors are saying that yes, they have established internal financial controls which are adequate and effective. Then C stands for compliance system. That the directors are saying that yes, we have a proper compliance system in place and the compliance system is adequate and effective. Then G stands for going concern, that the accounts have been prepared on going concern basis. And J stands for judgments, that wherever judgments and estimates had to be made, the directors have made the judgments and estimates in a prudent manner, thereby giving true and fair view of the state of affairs of the company. So these are the 9 responsibilities of the directors which will be mentioned in the board report. In the board report, the directors will mention that they have fulfilled these 9 responsibilities. See, I'll show you how to remember now. These 3 points will be one bucket. These 2 points will be one bucket. If you have this guidance, rest of the answer you will be able to write properly. Point number 1, accounting standards have been properly followed. If there's any departure, explanation has been given. Second point, accounting policies have been applied consistently. Then third, fourth and fifth point, why same bucket? Because we have proper and sufficient care in all of them. So the directors have taken proper and sufficient care in maintaining accounting records. They have taken proper and sufficient care in safeguarding the assets of the company. They have taken proper and sufficient care in preventing and detecting fraud. Okay, easy to remember. So 3 points with proper and sufficient care. Then we have 2 points with effective and adequate. So the internal financial controls are effective and adequate. The compliance systems are effective and adequate. If you learn like this, your keywords will not go wrong. Okay. And in the last 2 points, the accounts are prepared on going concern basis. And wherever judgments and estimates had to be made, the directors have made the judgments in a reasonable and prudent manner. Okay. These are your 9 contents of director's responsibility statement. Okay. Then coming to the next point, who will sign the financial statements? See, the financial statements have to be first approved by the board of directors. The board cannot delegate this to anybody. The board itself has to approve the financial statements and then they will be signed. They will be signed by whom? They will be signed by 2 categories of people. Category number 1, chairperson of the company if he is authorized by the board, or can also be signed by 2 directors, out of which one of them will be managing director. Okay. Then comes second category. 3 people, guys. The CEO, the CFO and company secretary. Easy to remember. In the first category, chairperson if authorized by the board or by two directors, one of whom will be managing director. Second category, three people, CEO, CFO and CS. So they will sign the financial statements. But if it is a one-person company, guys, in one-person company, the financials will be signed by one director. Okay, simple. So but don't forget, we can't straight away sign the financial statements. First, they have to be approved by the board. Only then they can be signed. Alright, then coming to one last reminder in your accounts of companies chapter, see the books of accounts and the vouchers, everything has to be preserved by the company for at least 8 financial years. In case central government orders an investigation, then in that case central government may require the company to preserve for longer than 8 years also. But who will be responsible for this maintenance? Who will be responsible for this preservation? 4 people, guys. Managing director, whole-time director in charge of finance, then the CFO of the company and any other person who is made responsible by the board for this purpose. So 4 people, managing director, whole-time director in charge of finance, CFO and any other person who is made responsible by the board. Okay, so these were your reminders from the accounts of companies chapter. Now coming to the auditors chapter, first talking about branch audit. Who audits the branch office? Who audits a branch office will depend upon where is a branch situated. Is a branch situated in India or is a branch situated outside India? If the branch is situated in India, then we have two options, guys. Either the branch can be audited by the company's auditor itself, that is by the statutory auditor itself, or it can be audited by any other person who is qualified to be appointed as auditor of the company. Okay, if the branch is situated outside India, then we have three options. Either it can be audited by the company's auditor, or it can be audited by an accountant, or it can be audited by any other person who is qualified to be appointed as auditor in that foreign country. Okay guys, now whether the branch office is in India or whether it is outside India doesn't matter. The branch audit report has to be submitted by the branch auditor to the statutory auditor of the company. Okay, so who will do the branch audit depends upon where the branch is situated, but it doesn't matter what the case is. If there's a branch auditor, the branch auditor will submit his branch audit report to the statutory auditor. See, generally what happens, the statutory auditor prepares the audit report and it is prepared for the members of the company, right? But the branch auditor, when he prepares the branch audit report, he will not directly give it to the members. No, he will give it to the statutory auditor. The statutory auditor will deal with it. Okay, this was one point. Then comes another point from your auditors chapter, disqualifications of auditor. See, we know very well that a body corporate cannot be appointed as auditor, but there are some crucial points over here which you should remember. LLP, which is registered under LLP Act 2008, it's a body corporate, but it can still be appointed as auditor, guys. Now listen, can an individual chartered accountant be auditor? Yes. Partnership firm? Yes. LLP, even though it is a body corporate, still it's an exclusion, it's an exception. LLP can be appointed as auditor. But the question arises, can a foreign LLP be auditor of the company? No. Why no? Because only that LLP which is registered under LLP Act 2008, only that LLP which is incorporated in India, only that LLP can be appointed as an auditor. So if you're a foreign LLP or if you're a company, then you cannot be appointed as an auditor. Okay, no confusion guys. Yes, so individual chartered accountant can be an auditor, a partnership firm can be an auditor. LLP, even though it's a body corporate, it can still be an auditor, but Indian LLP, not foreign LLP. Okay, then comes my next reminder, remuneration of auditor. See, who fixes the remuneration? It all depends upon who appointed the auditor. Like the first auditor is appointed by the board, right? So therefore the board will fix the remuneration. But subsequent auditors are appointed by the members. So the members will fix the remuneration. So either the members will, in the general meeting, either they will fix the remuneration or they will decide the manner in which the remuneration will be fixed. So sometimes what happens is, it is just mentioned that the remuneration of the auditors will be mutually decided. So at least the manner is fixed by the members, right? That the remuneration will be mutually decided. So therefore even this will be perfectly valid. So it is not necessary that the members have to fix the amount only. They can also fix the manner. Like for example, they can say that the managing director will fix the remuneration. The members can decide like that. Or the members can decide that the remuneration will be mutually decided. That will be valid. So they can either fix the amount or they can fix the manner. That will be fine. Okay, that was your reminder number 31. Now comes your reminder number 32. 32, casual vacancy in the office of auditor. See, casual vacancy arises when the auditor either dies, or he attracts a disqualification, or he resigns, or he is removed even before his tenure is over. Now, if there's a casual vacancy in the office of auditor, the casual vacancy has to be filled. Now, who will fill? When will it be filled? All that will depend upon what kind of a company is it. If it happens to be a non-government company, then the casual vacancy will be filled by the board of directors within 30 days. Okay. But however, in the same non-government company, if the casual vacancy is because of resignation, same thing, the board will fill within 30 days, but we also need ratification. We also need approval of the shareholders in the general meeting by passing ordinary resolution within 3 months. But this is only in resignation cases, only in non-government companies. Okay. But if it happens to be a government company, then in that case, within 30 days from the vacancy, the CNAG will fill the casual vacancy by appointing a new auditor. But however, if the CNAG does not appoint the casual vacancy auditor within 30 days, then within the next 30 days, the board itself will appoint the casual vacancy auditor. Okay. But in this government company, whether the casual vacancy is because of resignation or not, no special treatment, same concept only, same procedure only. Alright. So remember, in non-government company, the casual vacancy auditor will be appointed by the board within 30 days. In government companies, it will be appointed by the CNAG within 30 days. Only when the CNAG doesn't apply, only when the CNAG doesn't appoint, only then within the next 30 days, board will appoint. In non-government companies, there's one extra responsibility, and that is, in case the casual vacancy is because of resignation, then we also need shareholders' ratification within 3 months by passing OR. And don't forget, guys, the casual vacancy auditor, his term will be only till the conclusion of the next AGM. Alright, that's it, guys. Simple point. Now come on, let's move on to our companies incorporated outside India. Here I want to give you 2 small reminders. Reminder number 1. If the company is incorporated outside India, this company, yes, it can issue a prospectus in India. It can raise money by issuing securities in India. It can issue a prospectus in India. But of course, some conditions have to be fulfilled. Like for example, a copy of that prospectus has to be filed with ROC New Delhi. Now don't say everywhere, ma'am, CRC, Central Registration Center, New Delhi. No. See, only for FC1. For that only you will say that it has to be filed with CRC New Delhi. Alright. But all other documents, all other forms have to be filed by the foreign company with ROC New Delhi only. Okay. So prospectus has to be filed with ROC New Delhi. Then the prospectus can contain an expert statement. If it contains expert statement, then expert's consent should also be attached. Now the important point that I wanted to give you a reminder is that to this prospectus, various documents have to be attached, guys. What are those attachments? Number 1, the expert's consent. This point will come into the picture only if the prospectus contains an expert statement. Then copy of the contract for appointment of MD or manager. Then copy of other material contracts. Then copy of underwriting agreement and copy of power of attorney. So all these 5 documents have to be attached to the prospectus, and this prospectus along with the attachments has to be filed with the ROC. Okay. Then one more reminder over here. See, just because a company is conducting board meetings in India, because of that reason alone, it will not become a foreign company. See, foreign company means what? It should be incorporated outside India. It should have a place of business in India, and in that place of business in India, it should be doing some business activity. But if the company is incorporated outside India, let us say, but board meetings alone are in India, because of that reason alone, it will not become a foreign company. One small point. Okay. Now giving you some reminders relating to your LLP chapter. Point number 1, winding up of LLP. See, LLP may either be wound up voluntarily, that is the partners, they themselves may decide to wind up the LLP, or the NCLT will interfere. Now when will the NCLT interfere? In 5 situations. Situation number 1. If the LLP itself is deciding that we will be wound up by the NCLT, then NCLT will interfere. Situation number 1. Situation number 2. See, LLP requires minimum 2 partners, guys. In case LLP is continuing for more than 6 months with less than 2 partners, then the NCLT will interfere and will ask the LLP to wind up. Then number 3, if the LLP is defaulting in filing the statement of accounts and solvency or annual return for 5 consecutive financial years, 5 consecutive years, statement of accounts and solvency or annual return not filed with ROC, then the NCLT will wind up the LLP. And then if the LLP is acting against the sovereignty, integrity or security of our country, like for example, if the LLP is getting involved in terrorism activities, gone, the NCLT will wind wind up the LLP. And lastly, any other just and equitable grounds. So the LLP can be wound up either voluntarily by the partners on their own itself, they can wind up the LLP, or it may be wound up by the NCLT. But NCLT will interfere only in these 5 cases. Number 1, when the LLP itself decides. Number 2, when the number of partners falls less than 2 and the LLP is continuing business for more than 6 months like this. Then number 3, the LLP is not filing statement of accounts and solvency or the annual return for 5 consecutive financial years. Again, the NCLT will wind up the LLP. Then number 4, the LLP is getting involved in activities which are against the sovereignty, integrity or security of our country. And lastly, any other just and equitable grounds. Okay. Then comes my next reminder, another reminder from the LLP Act. See, the partner of the LLP, he has a right to get share of profit from the LLP, guys. And similarly, if the LLP is suffering a loss, then the partner will have to bear the share of loss as well. Also, the partner will have the right to get distributions from LLP and all. So all of these, the partner, if he thinks it is required, he can transfer all of these to another person. So let's say I am a partner of the LLP. I have the right to get the share of profit from the LLP, right? I can assign that right to get the share of profit to you, let's say. So in this case, I become the transferor and you become the transferee. Alright, now when this happens, even though I have transferred to you my right to get the share in the profits, doesn't matter, still I continue to be the partner, guys. Doesn't mean that I get disassociated. No, I continue to be the partner. LLP still continues. LLP doesn't get dissolved. LLP doesn't get wound up. Everything continues life as usual. And just because you are having the right now to enjoy the share of profit of LLP, because of that reason alone, you will not become the partner of the LLP. Assignee will not become the partner. Transferee will not become the partner. You cannot ask to participate in the management of the LLP. You cannot ask for information and books of accounts of the LLP. No, you do not become a partner just because you're having the right to enjoy a share of profit of the LLP. Okay, so yes, assignment and transfer is allowed in LLP, but however, just because the assignment has happened, because of that reason alone, doesn't mean that I'm not a partner anymore. I will continue to be the partner, and just because I'm assigning the right to get the share of profit to you, you will not become the partner. I only will continue to be the partner. Okay. This is about assignment. Then comes our next reminder about the liability. See, when it comes to the liability of partners in LLP, we do know that the liability of partners is limited. But there are so many more points about liability that we should also know about. I want to remind you about that. See, when a partner is newly admitted into the LLP, whatever has happened in the LLP before his admission, for all those past acts, he will not be liable. Point number 1. Point number 2, the designated partner only has major liability in the LLP, guys. For all the compliances, it is a designated partner who is liable. In case the LLP has not filed some document with the ROC, in case LLP has not complied with any law, then the designated partner only will have to pay the penalties and all. So the designated partner is liable for all legal compliances. Then comes the third point, in case a partner dies, and if the LLP still continues with the same name, then in that case, the legal representative of the deceased partner will not be liable for the acts of the LLP after the death. Understanding? So 3 points. Point number 1, the once a partner is admitted into the LLP, before that, whatever actions, whatever omissions have happened in the LLP, for the past actions, the new partner will not be liable. Point number 2, the designated partner will be liable for all legal compliances. And point number 3, if a partner dies and if the LLP still continues under the same name, in that case, the legal representative of the deceased partner will not be liable for the acts of the LLP after his death. Okay. Then comes the next set of reminders about change in particulars of the partners. See, we have to inform the ROC in 3 situations. Number 1, whenever a person becomes a partner. Whenever a new person becomes a partner, we have to inform the ROC. Similarly, when the existing partner ceases to be the partner, that is, for example, let's say he leaves the LLP, or let's say he resigns, or even in that case, you have to inform the ROC. Also, when the partner, his address or his name changes, even that has to be informed to the ROC. So 3 points we're going to be talking about over here. Point number 1, when a person becomes a partner of the LLP, within 30 days itself, LLP has to inform the ROC along with the copy of the written consent of the new incoming partner. Point number 1, when a person becomes a partner, inform ROC within 30 days. Point number 2, this is important, guys. See, when a person ceases to be a partner, when a person leaves the LLP, for example, in that case, the LLP has to inform ROC within 30 days. Okay. But however, in case the LLP does not inform the ROC within 30 days, then the partner itself can go and inform the ROC. But if the partner informs the ROC, ROC will not accept. ROC still needs confirmation from the LLP. So in that case, ROC will send a show cause notice to the LLP and will ask for confirmation within 15 days. Okay. Now, why is this so important? See, when a person ceases to be a partner, we have to inform ROC. Only then his cessation will be effective. Only then his liabilities and all will cease. So that is why, unless and until you inform the ROC about the cessation, unless and until you inform the ROC that this partner has left the LLP, unless you till you don't inform him, till then that cessation will not even be effective. Okay, so that is why it's very important to inform the ROC about cessation. So LLP will inform within 30 days. If the LLP doesn't inform, then the partner itself can inform the ROC. But if the partner informs ROC will not accept it. ROC still needs confirmation from whom? From the LLP. So ROC will send a show cause notice to the LLP and will ask for confirmation within the next 15 days. Okay. Then lastly, in case there's any change in the name or in the address of the partners, then the partner has to inform the LLP about it within 15 days. Within 15 days of the change. LLP will have to inform ROC within 30 days of the change. Please notice, both the time limits over here are from the date of change. So partner will inform LLP within 15 days of the change. The LLP will inform ROC within 30 days of the change. Okay, so 3 points we spoke about over here. Change in the particulars of partners. Then comes our next discussion, the number of partners. In every LLP, we need minimum 2 partners, guys. The partners can be individuals, they can be LLP, even a foreign LLP can be a partner in an LLP, even a company can be a partner in an LLP. But however, cooperative society and corporation sole, they cannot be appointed as partners in the LLP. Okay, now come on, look at this list and tell me one by one whether they can be partner in the LLP or not. Individual, yes, individual can be a partner. What about a foreign individual? Even a foreign individual can be a partner. LLP can be a partner in another LLP. Even a foreign LLP, whether Indian LLP, whether foreign LLP, they can be partners in another LLP. Similarly, whether Indian company, whether foreign company, they can be partners in an LLP. But however, a cooperative society cannot be a partner. A corporation sole cannot be a partner. HUF cannot be a partner. Trust, charitable trust cannot be a partner. Okay. Now see, minimum 2 partners. Now out of these 2 partners, minimum 2 individuals have to be designated partners. So minimum 2 partners we need. Out of the partners, we'll see who are the individual partners. Out of the individual partners, minimum 2 individuals will have to be designated partners. Now out of the designated partners, one of the individuals has to be a resident, which means should have stayed in India for at least 120 days in the financial year. Okay. Now see, what will happen if all the members of the LLP are body corporates? Then in that case, how will we have designated partners? Because only individuals can be designated partners. So, in case all the members of the LLP are body corporates, then those body corporates will appoint 2 nominees, guys. They will appoint 2 individuals as nominees. Those nominee individuals, they will be treated as designated partners. Okay. Now listen, LLP requires minimum 2 partners. Those 2 partners can be individuals or they can be body corporates. Now, out of the partners, we will see who are the individual partners. 2 of them will become designated partners. Out of the designated partners, one of them has to be a resident. Now see what will happen if the total number of partners in the LLP falls below 2. In that case, we will give the LLP 6 months time to bring the number of partners back to 2. If they are able to do it, great. But however, if the LLP continues with less than 2 partners for more than 6 months, then in that case, heavy consequence. In that case, what is the consequence? See, listen carefully. So if the number of partners has fallen below 2, which means we are having only 1 partner, guys. Now, in case the LLP has continued to do business only with 1 single partner for more than 6 months, then that 1 partner will become personally liable for all the obligations of the LLP which are incurred after the 6 months period. But he will have this personal liability only if he was aware of the fact that LLP was carrying on business only with him for more than 6 months. Understanding? So in case LLP, the number of partners falls below 2, which means let's say we have only 1 partner, in that case we will give the LLP 6 months time to bring the number of partners back to 2. But however, even after 6 months, if we still have only 1 single partner, then that 1 single partner will now become personally liable for LLP's obligations. Which obligations? Those obligations which are incurred after the 6 months period. But however, what's the precondition? This 1 single partner, he will be personally liable only if he was aware of the fact that for 6 months LLP has continued with only him as a partner. Okay, so this was about our LLP chapter. Then some reminders from a General Clauses Act. See, the authority who has the power to appoint a person will also have the power to suspend the person or dismiss the person. Like for example, if the Chief Justice has the power to appoint High Court officers, then the same Chief Justice can also suspend or dismiss the High Court officers. Okay. Similarly, the same authority can also increase or decrease the tenure of of the person whom they have appointed. Like for example, if the central government has appointed a commission, the central government can also change the tenure of the commission. They can also vary the terms of the appointment. They can also vary the tenure of the appointment. Okay. Then comes the next point, imprisonment. See, General Clauses Act says imprisonment means imprisonment as defined by the Indian Penal Code. Now, if you look at the Indian Penal Code, imprisonment can be of two types. It can either be rigorous imprisonment or it can be simple imprisonment. Now, whenever any offense is punishable with imprisonment, that imprisonment should be rigorous imprisonment or should it be simple imprisonment? The law doesn't say anything. The law lets the court decide. So depending upon how grave the offense is, depending upon how serious the offense is, on that basis, the court itself will make a decision. The court at its discretion, so the court will make the decision whether the imprisonment should be rigorous or whether it should be simple. So first of all, point number 1, General Clauses Act simply says that imprisonment means imprisonment as per Indian Penal Code. That's all. Indian Penal Code only says that there are two types of imprisonment. Now, out of the two, which imprisonment the court will order, that will depend upon the court's discretion. The court will decide that depending upon how serious the offense is. Okay. Then comes my next reminder, effect of repeal. See, if any old act is repealed and if a new act is reenacted in its place, like for example, the Companies Act 1956 was repealed. In its place, we had Companies Act 2013. Now, what will be the effect of repeal? 5 points you'll have to write. Point number 1, the repeal will not revive anything during the period for which the repeal is made, which means once Companies Act 1956 has been repealed, we cannot revive it back. We cannot bring it back. Point number 1. Point number 2, repeal will not affect anything which you have already performed under the repealed act. Under the 1956 Act, a company is already incorporated. That will not get affected. Anything which you have already done under the old Act will not get impacted. Then, third point, it will not affect any claim, privilege, responsibility or debt under the old Act. Under the old Act, you have submitted some application. It will still be valid. Under the old Act, you borrowed some loan. It will still be valid. So, the repeal will not affect any claim, privilege, responsibility, debt. All the 4 words you will write in the examination. CPRD. Claim, privilege, responsibility, debt. Claim, privilege, responsibility, debt. All these 4 will not get affected just because of the repeal. Okay. Then, repeal will not affect any punishment already sustained with respect to an offence committed. Under the 1956 Act, if any punishment was announced, that punishment will still continue. So, repeal will not affect punishment already ordered. Okay. Similarly, the repeal will not affect any RIL. The repeal will not affect any remedy, inquiry or litigation which was initiated before the repealing. Like for example, before the 1956 Act could be repealed, before that itself, if some case was filed in the court, for that case will still continue even after the repeal. That case will still continue under the 1956 Act. So the repeal will not affect any remedy, inquiry or litigation which was initiated even before the repeal. So 5 points guys, all the 5 points very important. Point number 1, once the act is repealed, we cannot revive it. Point number 1, we cannot revive it. Point number 2, repeal will not affect anything which is already performed under the repealed Act. Point number 3, repeal will not affect any claim, privilege, responsibility or debt incurred under the old Act. Then point number 4, repeal will not affect any punishment which has already been announced under the old Act. Point number 5, repeal will not affect any RIL, any remedy, inquiry or litigation which was initiated before the repeal itself. So these 5 will not get affected by repeal. Alright, then comes one last point over here. See, in case a particular act is repealed, like for example, the Companies Act 1956 has been repealed, okay, and in its place the Companies Act 2013 has come in. But however, the Income Tax Act 1961 still in multiple places still talks about Companies Act 1956. So even though the law has been repealed and even though a new provision has been enacted, still other laws may still talk about the old law. In that case, it will be deemed, it will be assumed that the reference is being made to the new act only. Okay, so in the other laws, even if reference is still made to the old act, it will be deemed as if reference is being made to the new act only. Okay, so this was your repeal discussion, section 6 and section 8. Guys, section 6, the 5 points are clear, right? Very important. Repeal will, once a law is repealed, you cannot revive the act. Then point number 2, once the act is repealed, it will not affect anything which you have already performed under the repealed act. Then once the act is repealed, it will not affect any claim, privilege, responsibility or debt which you have already incurred under the repealed act. Then once the act is repealed, it will not affect any punishment which has been sustained under the repealed act. And once the act is repealed, it will not affect any remedy, inquiry or litigation which was already initiated before the repeal itself. Okay, I hope you've understood this. Multiple times I've given you a revision of the revision. I hope it's nicely gone and settled in your mind now. Now comes my next reminder, immovable property. See, immovable property includes land, benefits arising out of land, things attached to the earth, and things permanently fastened to anything attached to the earth. Tell me the four things: land, benefits arising out of land, things attached to the earth, and things permanently fastened to anything attached to the earth. Okay, now there are some examples of immovable property. Trees, they are benefits arising out of land. Right of way to access, nothing but your roads, even they will come under immovable property. Then machinery fixed to the soil. See, even this will be immovable property because this will come under things attached to the earth, guys, because it is fixed to the soil. And standing crops. So immovable property includes land, benefits arising out of land, things attached to the earth, and things permanently fastened to anything attached to the earth. So we saw some special examples: trees, right of way to access, machinery fixed to the soil, and standing crops. But however, timber, see, as long as a tree is rooted to the soil, it is immovable property. But once you chop the tree and get the timber out of it, timber is not immovable property anymore. Similarly, the right to drain water is also not immovable property. Okay, now this is fine. Till here you were already aware of. There was nothing new for you at all over here. But however, I have a list of some more examples, guys, that you must be aware of with respect to immovable property. An agreement to convey forest produce like tendu leaves, timber, bamboo, the soil for making bricks, then right to build on and occupy the land for business purpose, basically the right to build, then right to grow new trees and to get leaves from trees that grow, right to conduct mineral operations, right to extract minerals, right to receive future rent, all these come under immovable property. See, arrears of rent is not immovable property, but right to receive future rent, that will come under immovable property because it will become benefit arising from land. Then plantation of 200 timber trees, industrial warehouse, farmland, doors and windows of the house, stone pavilions, historical monuments, all of these are additional examples of immovable property. Be careful. Okay, then comes my next reminder. Whenever we have to measure distance is never measured on the basis of roadways. No. Distance is never measured on the basis of waterways and all. No. Distance is always measured in a straight line on a horizontal plane. In simple words, we always measure distance aerially. Okay, crow flying distance, aerial distance, that is straight line on a horizontal plane. Then comes my next point. Whenever the laws talks about the masculine gender, it will also automatically include the feminine gender and vice versa. So like for example, the Income Tax Act refers to the assessee as he. He shall file his income tax return. He shall pay his income tax. So here there's reference to the masculine gender, but it will also automatically include the reference to the feminine gender also. So men and women both will have to file return. Both will have to pay their taxes. Understanding? So reference to the masculine gender will also include reference to the female gender and vice versa. But however, be careful. When the law happens to be a succession law, if you're interpreting a succession law, that is an inheritance law, you have to be careful. In inheritance laws, in succession laws, male descendants will mean male descendants only. It will not include female descendants. Generally, what did we learn? Generally, reference to masculine gender will also include reference to feminine gender, guys, but not in succession laws, not in inheritance laws. In these kind of laws, reference to the male gender will be reference to the male gender only. It will not apply to female gender. Okay, guys. Now listen. You have to listen to my next point very carefully. In one explanation itself, it has to get registered in your mind. See, we have this word cattle. We have a common word. Why am I calling it common word? Because cattle will include both the female gender, which is cow, and the male gender, which is bull. It will cover both, guys. Now, when a word denoting both the genders is available, when a word denoting common gender is available, still, if a particular law says that this particular land will be used for grazing of cows only, then here you cannot say that cows will include bulls also. You cannot say, because if the law wanted this provision to apply to both the genders, the law could have used the word cattle, isn't it? So when a word denoting common gender is available, but still if the law has specifically used a word which denotes a specific gender, then you cannot say that masculine will include female and female will include masculine. You cannot say like that. Understanding? So when a word connoting common gender is available, the word cattle is available, but still if the law uses a word which conveys a specific gender, so even though the word cattle is available, still if the law talks about cows, then you cannot say that masculine gender will include feminine gender, feminine will include masculine. You can't say that. So example, in this case, the word bullock will not include cows, because if the law wanted to talk about both bull and cow, they would have used the word cattle, but they did not use. Instead, they use the word cow. So cow means it will refer to cow only, female gender only, and not the masculine gender. Okay, guys. And lastly, singular will include plural, plural will include singular. You're already aware of this. Okay. But wait, I have one point to tell you about this singular and plural point. Like, let us say the law says one company. Singular, guys. So here, will you say that one company includes many companies? No. When the law uses a number, one company means one company only. But however, when the law says a company, it is written in singular. Here you will say that singular includes plural. So a company will include many companies also. Okay. So if the law uses a number, then one means one only. But if the law does not use a number, it just says a company. It has written company in singular. So singular will include plural, plural will include singular in such cases. Alright, so then coming to one last reminder from GC Act, the definition of affidavit. Affidavit includes affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. I just wanted to give you a reminder of the definition, guys. Affidavit includes affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. So you have two options. Either you can come to the court, you can stand in the witness box, and you can swear that whatever you are going to say is the truth and not a lie. Either you can come to the court, swear honesty, swear that you will be honest, and then make the statement, or you can simply give an affidavit. So in an affidavit, you cannot write a lie. You cannot write a false statement because it has the same value as swearing in court. So affidavit is nothing but a statement, a declaration, a written declaration. It's an affirmation and a declaration in the case of persons by law allowed to affirm or declare instead of swearing. Okay. Then interpretation of statutes. Here I have two reminders. One is rule of literal interpretation and the other is dictionary definitions. I'll come to these two at the end. Let me finish off FEMA first. See, under FEMA I want to give you two reminders. The first reminder is about LRS, Liberalized Remittance Scheme. Now Liberalized Remittance Scheme applies to those individuals who are PRI. Okay, so these individuals who are PRIs, if they do any current account transactions mentioned in Schedule 3 or capital account transactions mentioned in Schedule 1, basically wherever RBI approval is required. So if you're an individual and if you're a PRI, then if you require any foreign exchange, if you want to draw any foreign exchange, either for a current account transaction mentioned in Schedule 3 or for a capital account transaction mentioned in Schedule 1 where RBI approval is required, okay, and all these transactions put together, if the total amount of foreign exchange that you need during the year is within $250,000, then RBI approval is not required. Only if you want to draw foreign exchange for these two transactions put together more than $250,000, only then you will require RBI approval for the excess. Up to $250,000, you will not require any RBI approval. For which transactions, guys? Not for transactions which come under central government approval, no. LRS is a scheme which is brought by RBI to make its work lighter. So wherever RBI approval is required, those transactions put together per annum, you have $250,000 limit. So wherever RBI approval is required, those transactions put together during the year, if the limit is within, if the total amount of foreign exchange that you need is within the limit of $250,000, then you don't require RBI approval. However, three transactions, guys: emigration, medical treatment abroad, and studies abroad. All the three transactions come under current account Schedule 3 transactions. For these three transactions, even if you want foreign exchange more than the limit allowed, no RBI approval required, provided you have proper estimates, provided you are drawing foreign exchange on the basis of valid estimates. Then in that case, even though you are drawing more than the limit, still RBI approval will not be required because you are having certificates which contain the estimates. Okay, but however, if you want to remit money to non-cooperative countries or to territories notified by FATF, Financial Action Task Force, like North Korea and all, if you want to remit money to non-cooperative countries or to countries notified by Financial Action Task Force, there you can't take the help of LRS and all. You will still require RBI approval. Even if it is within the limit, you will still require RBI approval. So we are giving you the freedom to remit up to this limit without RBI approval, provided you are remitting to a country which is not a non-cooperative country, not a country notified by FATF. Because if it is a non-cooperative country or a country notified by FATF, then it will not come under LRS, which means you will still require RBI approval. Even if the amount that you're drawing is within the limit, you will still require RBI approval. Okay. Then comes one last reminder, guys. Residential status of individuals. See, if an individual leaves India, if he leaves India for three purposes. Which three purposes? Either for the purpose of his employment outside India, or for the purpose of business or vocation outside India, or for any uncertain period, guys. We don't know when he is going to come back. So if a person leaves India for any of these three purposes, I will not care about 182 days criteria. I will straight away conclude that he has become PROI. Similarly, if an individual comes to India for any of these three purposes, I will not check 182 days criteria. I will straight away say that this person is PRI. So if an individual leaves India for these three purposes, then irrespective of 182 days criteria, that person will become PROI. Similarly, if a person comes to India for any of these three purposes, irrespective of 182 days criteria, that person will become PRI. Okay, so these were the 50 reminders I wanted to give you, guys. These are those last minute reminders, crucial concepts, highly probable in the examination. These are those 50 concepts where nice silly mistakes are possible in the examination, and that is what we're trying to eliminate over here. Trust me when I say this, if you have actually watched this entire video till the very end, this 1 hour of video, okay, will assure you minimum of 10 to 15 marks in the examination question paper, and this is a very conservative number that I'm telling you. Alright, it is going to help you in some form or the other. Same thing happened even in the September 25 exam as well. Same thing happened in the May 25 exam as well. This is a third examination where I am making this last minute 50 reminder video. Alright, these 50 reminders touching upon all the chapters of your syllabus. See, of course I'm not saying that the whole syllabus is revised in 1 hour. Of course not. But at least the crucial points, the points which you should keep in your mind, the points which you cannot mess up in the examination, we've spoken about them all. Now what are you going to do? You're going to have a calm mind. No tension. How much ever got covered, how much ever has been done, it's all fine. Everything is under control. That is what you will tell yourself. You have all the knowledge in your mind. It will all get reminded to you at the right point of time during the examination. So trust your preparation, have nice belief that you have done your very best, and go to the examination with a calm mind, because if you are able to walk into the examination hall with a calm mind, trust me when I say this, that itself means you have won half the battle. Okay guys, so go out there today and rock the examination in those 3 hours, and when you come out of the examination hall, you should feel really proud of yourself that you've done the best that was even possible from your end. Okay, all the best guys, bye bye.